Trump's lawyers argued that Donald Trump should be immune from criminal prosecution. They want total immunity. The judges seem to challenge that argument. They just weren't buying it.
Because for over 200 years, the courts have held we can't sit in judgment over the president's official acts under any circumstances. So, for example, Mississippi against Johnson. No. That's correct. It's never arisen until this case. That is absolutely correct. But if you look at every civil context, what they've said, you keep in mind that what Chief Justice Marshall says is never examinable. Never examinable. So there would be no judicial proceeding where you could say the president did this and we're going to sit in judgment directly over that. That's reinforced by Mississippi against Johnson, by Swan against Clinton from this court more recently, where the courts hold that we can't even enjoin or even really enter a declaratory judgment directly against the president for his official acts.
Judge Karen Henderson is questioning. Now, she is a George H.W. Bush appointee. She asked about Trump and the Constitution's Take Care Clause. It requires a president to follow the law.
His constitutional duty to take care that the laws be faithfully executed requires him to follow those laws, every one of them.
Yeah. I would say that the Take Care Clause, carrying out one's duties in the Take Care Clause, are inherently discretionary. An example of a ministerial act, for example, in Marbury against Madison is like delivering a seal when you're requested, because there's a separate statute, right? What they emphasize is there's a separate statute. The Secretary of State had kind of these two hats on. He was, on one hand, a direct agent of the president, and in that, this could never be examined by the courts. On the other hand, the original statute had imposed all these like purely ministerial duties that had to do with record keeping and delivering documents. Like if you got a land deed that's got a seal on it and a person asks for it, where there's no discretion at all. When you're talking about the Take Care Clause, there's no statute that could impose on the president a mandatory duty to engage. I mean, the notion that when the president's meeting with the Department of Justice, for example, saying, hey, we should investigate and enforce federal fraud statutes, the notion that that's ministerial strikes me as insupportable.
I think it's paradoxical to say that his constitutional duty to take care that the laws be faithfully executed allows him to violate criminal laws. Now, we're at the motion to dismiss stage. The government has charged the specific criminal laws. We have to assume they're true.
I mean, my response to that, I think, would be to emphasize what Chief Justice Marshall said in Marbury, which is that they can never be examined by courts. That naturally includes a criminal proceeding.
But I thought you agreed with me that we've gotten beyond Marbury in the sense that official acts has been subdivided into discretionary and duty-bound or ministerial. And in the ministerial or duty-bound, at least with respect to even legislators and judges, they have been held criminally liable. And that's in the face, at least with respect to the legislators, of an explicit constitutional privilege.
Officer is immune. It did not say there could never be raised an immunity defense. It said criminal process can go forward.
There's a quote in the Congressional record in which your client said through counsel, no former office holder is immune from investigation and prosecution.
Investigation is what there's no immunity to. Well, that may be true of subordinate officers, but as to the principal officer, the president, he is immune unless he is impeached and convicted. Again, it comes back to the point we made.
He was president at the time, and his position was that no former office holder is immune. And in fact, the argument was there's no need to vote for impeachment because we have this backstop, which is criminal prosecution. And it seems that many senators relied on that in voting to acquit.
I realize in speculation, I think statement. The court, I think, lacks the ability to intuit what motivated senators' votes in the impeachment process. What the Constitution says is you must be impeached.
I think the question that Judge Henderson was asking you was you took the position, or your client did, during the impeachment proceedings, that there would be an option for criminal prosecution later, and it's in the Congressional record. And I guess the question is, what has changed, or why have you changed your position?
agree with that characterization of the statements in the congressional record. I believe there was a distinction between the judicial process and the investigative process. That was in the quote that I just read. In addition to that, whatever concession may or may not have been made there would not have a res judicata effect in this proceeding. These are very different proceedings.
This is James Pierce's opening statement. He's from the Justice Department, Assistant Special Counsel.
Good morning, and may it please the court. Never in our nation's history until this case has a president claimed that immunity from criminal prosecution extends beyond his time in office. The president has a unique constitutional role, but he is not above the law. Separation of powers principles, constitutional text, history, and the defendant's theory over the course of this litigation has evolved a bit, and I think now before this court, I understand the argument to be principally sort of a principal submission to be, as you've just described, this what we call in our brief the conditioned precedent argument, that there is only liability, criminal liability for a former president if that president has been impeached and convicted. And that is wrong for textual, structural, historical reasons, and a host of practical ones, one of which I'll start with, again, to just amplify the point. It would mean that if a former president engages in assassination, selling pardons, these kinds of things, and then isn't impeached and convicted, there is no accountability for that individual. And that is frightening.
And that is frightening. That's the bite I'm going to end on. Complete immunity for a president. That's frightening.